read you. It's a yes or no question.
Pro se. What does pro se mean to you?
All right. Hold on. Mr. Beller, you need to wait. Okay.
I'm actually pro se. I'm representing myself.
No, you're
Malcolm. Yes, I filed pro se on myself, so I'm representing myself. Madeline Malcolm, I've informed her that she is no longer representing me. I am a pro se litigator and representing myself. Madeline Malcolm has no business being in the courtroom representing me today.
All right, the court calls 25M 1656, 25 CR 1110, 25 CR 1002, 25M 1537, and 25M 1600. Mr. Keller, I'm sorry, Mr. Beller appears by WebEx today instead of in person. And from the jail, why is he appearing from WebEx?
Because of custody restrictions.
Yeah, it's a housing restriction.
All right, thank you. All right, then what the case comes on for today is motions hearing. The motions were filed timely in 25 CR 1002. However, there has been a motion in one of the cases to a motion with regard to having a competency evaluation. Ms. Malcolm, I noticed that this is not filed in all of his cases.
Your Honor,
hold on. Mr. Beller, you need to wait. Okay.
I'm actually pro se. I'm representing myself.
No, you're
Malcolm,
not.
yes, I filed pro se on myself, so I'm representing myself. Madeline Malcolm, I've informed her that she is no longer representing me. I am a pro se litigator and representing myself. Madeline Malcolm has no business being in the courtroom representing me today.
I have not approved, nor have I considered any motion to
Commander
have counsel
Bond,
dismissed.
I've already put
Mr.
in
Beller,
pro se.
Mr. Beller, you need to stop.
You're not understanding what I'm saying.
Mr. Beller,
Commander Bond is.
All right. The court notes that there has been a motion filed, as I said, raising competency in one of the cases. It has not been filed in all of the cases.
I apologize for that, Judge. I can file it in the rest of the cases.
Okay, so that it's your intent to file it in all the cases?
It is. I was just filing all the motions in that case. And I should have done the others.
All right. For the record, the court muted Mr. Beller as he was not abiding by the court's order to stop talking over me. Mr. Beller, I have to advise you of your competency and the motion that's been raised by counsel with regard to your competency. I'm going to read the advisement to you, and you need to listen to it. And then I will unmute you, and you can ask questions at that time. Do you understand? You can nod your head yes if you understand me. Well, the court notes that there was evaluated by one or more physicians or psychologists. Because your attorney has raised the issue of competency, this constitutes a waiver of privilege to reports of this or subsequent competency evaluations, as well as information relied upon by the evaluators. You have the right to remain silent during the evaluation. However, such silence may be used by the evaluators to determine your competency. Any statements you choose to provide in cooperation with the evaluation may be used by the prosecution as either impeachment or rebuttal evidence if you testify at any subsequent criminal trial and at any sentencing hearing held in the case if you are found guilty. You have the right to request an evidentiary hearing to contest any determination of competency. You have the right to be re-examined by an expert of your choice on the issue of competency. A copy of any report generated by that expert will be provided to the prosecution. At a hearing to determine your competency, you have the right to be present in person to examine any reports of the evaluation or other matters to be considered by the witnesses called by the court, to introduce evidence, summon witnesses, cross-examine opposing witnesses, or witnesses called by the court, and to make an opening statement and closing argument. If you're found incompetent to proceed, then the criminal proceedings will be suspended and you may be committed to the Department of Human Services for a portion of the maximum term of confinement that could be imposed for the highest level of offense with which you are charged. Restoration services may begin immediately unless either party objects, in which case the court will hold a hearing on the objection. If committed, you have the right to request a hearing as to whether your competency has been restored. If you find if you're found to be restored to competency, then the criminal proceedings will resume. Let me ask you, Ms. Malcolm, I also note Ms. Bovee is on the case. Ms. Malcolm, did you have an opportunity to speak with your client with regard to the issue?
I did not. I was trying to. He did not want to talk about it.
Okay, that's fine. All right, then,
The so-called public defender. And
Mr. Beller, the court is now going to ask you if you understand the rights that the court just read to you.
I've already gone to the Colorado Institute for Mental Health in Pueblo and been found competent. I've already had 3 competency evaluations. The fact that you're trying to raise competency again, okay, it's a gross violation of my right to speedy trial.
I only
And
asked
my
you, Mr.
rights.
Beller, if you
Okay.
understand the rights that the court just read
I
you. It's a
am
yes or no question.
pro se. What does pro se mean to you?
All right. The court finds that Mr. Beller is not answering the question with regard to understanding his rights, and
No,
that's
I
okay.
understand my rights, my Miranda rights. What
It's
are the
not
rights?
Miranda rights. Do not unmute him again from the sheriff's office. All right. So the court is going to order the Department of Human Services to conduct a competency evaluation of Mr. Beller. The evaluation will occur at the jail, and the court will review this in 28 days to determine whether or not the evaluation has taken place. The court notes that the last competency evaluation was conducted in January, and Mr. Beller was found competent at that time. However, his attorney has raised the issue again, and the court finds it appropriate to conduct a new evaluation. And that'll be the order of the court. The court will stay the motions hearing and the jury trial that's set for August 17th until such time as the court hears back from the evaluator from DHS. I'm sorry, Ms. Jones, I failed to mention that you're here. On behalf of the district attorney's office, that's my fault. Ms. Jones.
Your Honor, I just want to make sure that the record is clear since we, with setting a new review date in 28 days, that's going to be within the time that the current jury trial is set. And I know the court just made the record that the proceedings are stayed. So I just want to make a record on speedy trial.
Certainly.
So that when we come back, if it's, depending on what the evaluation is, that we know what that amount of time is. So from my perspective, under the speedy trial statute, that the defense filed their motion to raise competency on June 24th, and then the court, I think on June 26th, filed the motion to convert this for the advisement. I think that's when the issue was raised. And so my perspective is that there should be a tolling from that date to, when the next hearing is. But calculating from June 24th to speedy trial currently is October 15th. So I'm calculating 113 days is remaining on speedy. And I just wanted to put that on the record so that we have that, because I have a concern speedy might be an issue when proceedings restart.
Okay, I don't share the concern. I understand the people's issue.
Mhm.
Speedy's told from, and the court typically tolls it from the time that I do the order, which would be today.
Okay.
I'm not going to toll it because I didn't make the determination until today that there would be an evaluation, so I've got to toll it from today's date. That said, Speedy's told, that's statutory, and the court, if that happens, if it happens that we get the evaluation back before the trial date, then we'll deal with that tolling and add the number to that date, but I don't foresee that occurring. That said, we'll take it up as soon as I have the status of the evaluation back. Let's set it for a review. Well, when did I said 28 days, right? So what date do we have for review? All right, that is the trial.
Yes.
Let's set it for the trial date, so the Monday at 8:15. So August 17th at 8:15.
Is the court going to maintain the trial date, I guess, is my question, because motions have been filed by defense. And so
Well, let me ask what the defense would like to do. Right now, motions have been filed. any hearing, as I said on the record, will be told until this evaluation is done, which means they're going to be reset.
Right.
I'm not taking them off in the very unlikely event. I'm not going to take the trial date off just yet. In the unlikely event that we get an evaluation back, that evaluation says he's competent to proceed, and then we can discuss how the trial should come off if it's before August 17th, which I don't believe that that will happen.
Correct. So that's why, from my perspective, I don't think it makes sense to maintain the current set trial date. And it's just going to be, we're going to have to reset within the remaining days that we have at that point in time.
I like to get to that point and then we'll have the calculation at least.
Okay.
I honestly don't care either way. It's just, I'm thinking, I think into the future about the calculation, and it's easier to this court to have the date set for trial that's set, because I don't really have, although that said, I don't have a position from the defense. We can vacate the trial, we can vacate the motions hearing and reset at a later time. That's fine with the court.
At this point, if the trial date was set and he was found competent before the trial date, I would have to ask Mr. Beller to choose between some constitutional rights.
That's right.
And I'd have to consult with him. So I don't have the answer right now because I can't consult with my client.
All right, then let's keep the trial date set. Let's report on August 17th at 8:15, and then we can deal with whatever the situation is at that time.
Okay.
All right, anything further?
So Judge, before we go, I know Mr. Beller is talking. I really want you to listen to me. I know you don't want me to represent you. Your mother is here. She wants me to talk to me about the case. If you're okay with that, nod yes. Okay, no. Okay, thank you. That's just the answer I've been looking for from you,
All right, we'll be in recess.
Judge.
Thank you.